Car accident injury claim. How mediation works. Hi, I'm attorney John Sheehan. Since 1993, I've represented thousands of injured workers and car accident victims throughout Massachusetts. Mediation is a form of alternative dispute resolution that allows parties, a personal injury claimant and the insurance company, to try and settle the personal injury claim out of court. A mediator serves as a neutral. Mediators are usually lawyers with years of experience, either defending claims for insurance companies or representing accident victims, or in many cases they've done both. They've been on both sides. Sometimes a mediator could also be a retired judge, either a superior or district court judge in Massachusetts. It's important that your lawyer select the right mediator. You want a mediator with experience, that has a good reputation, a mediator that treats the parties well, that is not just there to try and lowball the personal injury claimant. A mediator that's respected both by the insurance defense bar and the plaintiff's bar. It's important that you select a mediator that the insurance adjuster will listen to. At the agreed date and time, the parties will appear at the mediator's office. I'll go with my client and perhaps the client's spouse. The insurance defense lawyer will be there, the insurance lawyer that's representing the at-fault driver, and the adjuster will be there. Usually what happens is we all meet together in a large conference room. The mediator will welcome everyone, will explain the process, and then would usually invite myself to make some opening remarks to be able to describe our point of view of the case, the pieces of evidence that support our claim that the car accident was caused by the other driver's negligence and carelessness, explain the injuries that my client sustained, the treatment that my client had, and what the damages are, the amount of medical bills, lost wages, if there's any type of permanent injury that my client sustained, to be able to explain that, referring to the medical records and doctor's reports. I might utilize some photographs to illustrate the points that I'm making. Before the mediation, the lawyers would have provided the mediator with a brief summary of our view of the case and where things stand as far as litigation, if there's a trial date, and where things stand as far as settlement, if there's been a demand, if there have been offers, and where we stand going into the mediation as far as that goes. Once the lawyers for the parties have made their opening remarks, then the mediator will separate the parties, taking the insurance lawyer and the adjuster to another office or another room, so that the mediator can talk in private separately to both parties. And the point of that, or the purpose of that, is to allow the parties to put their cards on the table and to speak more frankly and openly to the mediator, knowing that what you say to the mediator is in confidence. And because of all that, mediation is confidential. Everything that's said at mediation is confidential. It cannot be used in court. It cannot be offered as evidence at a later trial. One of the good things about mediation is that you have nothing to lose. You can always walk away. Once in a while, I hear some lawyers talking or bragging about how they got up and walked away. They folded up their tent, took their briefcase and walked out of the mediation within the first hour. To me, that's a mistake. There might be times or circumstances that justify that, but in most situations, it's better to work it out, to ride it out, to let the mediator help if there's a bump in the road with the settlement negotiations. The worst thing is to dig your heels in. You want to be able to see what the insurance company is willing to offer that day. What's their final offer? You can always reject it. You can always walk away. And I've had experience where, while a case might not settle on the day of the mediation, sometimes it will settle within a few days or weeks after the mediation. A good mediator will stay with it. A good mediator will continue to follow up with the parties to see if the mediator can bridge any gaps to allow the parties to meet at an acceptable point to be able to settle the case. The mediator cannot force a settlement. The mediator's job is to try and facilitate a settlement agreed to by the parties. One of the good things about mediation is that the mediator will be able to give you the other side's point of view and give you his point of view as far as the merits of your case and as far as the weaknesses of the case. In most cases have weaknesses. So it's good to be able to hear some other perspective. It's good for my client to be able to hear some other perspective about how a judge, about how a jury may see their case, so that they can make an informed decision, a good decision, when it comes to considering settlement offers. When it comes to settlement, my old law school professor used to always say that a good settlement is better than a bad judgment. So what that means is, with the settlement, you control your destiny, you control the outcome. With a trial, all bets are off. You have no idea what 12 or 6 strangers are going to do in the jury box, listening to the evidence in the case. They might not believe you, or they might feel bad for the defendant, or they might think that both you and the defendant were partly at fault. They might not believe all of your medical treatment. They might not believe the seriousness of your injuries. Or they might really believe in your case. They might feel that the defendant was negligent. They might feel that you were injured and sustained damages, but their valuation, their conclusion as to the amount of damages and how much money will compensate you for the damages might be much different than what is being offered. If you've been injured in a car accident in Massachusetts and would like to talk to me about your case, please feel free to call or text me at the number below. And if you'd like to see my future videos, please subscribe to my YouTube channel.